Tulas, let's start with what we heard from Jacob Zuma's lawyer. He seemed quite aggressive, didn't he, when he made his arguments? Give us the core of what he said.
I call it throwing everything, including the kitchen sink, at them, Shahan, in terms of the arguments that were made by Advocate Muzi Sikhakhane. About 6 grounds that they were outlining in terms of what they believe establish the standard of a reasonable perception of bias, which is really what they need to do. That's the bar that they need to meet, and it comes back to that judgment from all those years ago that involved the South African Rugby Federation Union, SARFU, and the then President Nelson Mandela. And among those grounds, Shahan, was the whole suggestion that in terms of the sequencing of the witnesses to be heard by the Commission of Inquiry, that order, the sequencing was done such that it basically was the witnesses that support a narrative that appears to have been accepted by the Commission, including its chairperson, that 1, there was state capture, and 2, former President Jacob Zuma was at the heart of it. Well, in the afternoon, we then heard the response from Advocate Paul Pretorius about that particular argument that says even the sequencing of witnesses reveals a bias and an inclination to accept a particular version that, according to Advocate Sikhakhane, was presented by the sweetheart witnesses of the Commission who support this narrative that has already been laid out. Listen to how Paul Pretorius, Advocate Paul Pretorius, responded to that allegation around the sequencing of witnesses.
Having called 257 witnesses, it could not possibly be said that all those witnesses have been called according to a predetermined plan or project. But what is worth noting is that amongst those 257 witnesses that have been called is the son of the former president, Duduzane Zuma, Ms. Dudumiyeni, and others who clearly do not fall into the category of witnesses that has been put before you as being a category of witnesses, and we don't admit that for a second, Chair.
All right, so Tulas, let's continue this on what Advocate Paul Pretorius had to say, especially when it came to the argument of bias in relation to assertions about people who testified at this commission so far. He mentioned 2 aspects. Take us through that.
Well, the other aspect that he talked to very forcefully there, Paul Pretorius, in the afternoon, Shahan, had to do with the whole question of the apprehension of bias on the part of a witness who would be watching some of the questions that the Deputy Chief Justice poses on some of the witnesses that come forward. So basically the suggestion is that in some instances, the chairperson of the commission, Deputy Chief Justice Zondo, makes certain comments and asks certain questions that seek to suggest that there's a version that he has sort of accepted in a way, so he's too involved, is the suggestion from Advocate Muzi Sikhakhane, to which, of course, there's been a response. And I bring into this conversation Michael Appel. So, Michael, we had about 6 grounds, and one of the grounds had to do with just how involved Deputy Chief Justice Raymond Zondo is in the questioning of witnesses, and some of the questions that he asks. Advocate Muzi Sikhakhane is suggesting that they reveal a particular inclination on the part of the chairperson of the commission, which in return causes a sort of apprehension on the part of former President Jacob Zuma. What was the nub of Paul Pretorius' response to that?
Well, Paul Pretorius' argument is, I don't presume to tell you how to do your job, Raymond Zondo, but let me tell you what your job is. It is to be in this inquisitorial process. Remember, this is not a criminal trial, this is not adversarial process. Inquisitorial. By its very nature, you need to inquire. You can only inquire if you ask questions, if you interrogate, if you test versions, if you ask people questions related to their evidence. He's saying you are simply doing your job and nothing more than that. And he basically just outlined that the Commission of Inquiry has a mandate to test versions, to find the facts, and to ultimately come out with recommendations that can be put to the National Prosecuting Authority, where then it can be decided on whether or not there is guilt or lack thereof. So let's listen into a soundbite from Advocate Paul Pretorius speaking about the role, the very crucial role that the inquiry chairperson plays.
The applicant's assertion reveals two aspects, however. First, we submit to you that there's a lack of appreciation of the duties of the chair in an inquisitorial setting. It's your job, Chair, not the job of the legal team, to interrogate the witnesses, to put versions to them, to make sure you understand what their version is, and to highlight what issues of concern you have, not only for that witness, but for other people observing the proceedings who might or might not be implicated. If you did not do so, Chair, you would be failing in your duties as chair of an inquisitorial proceeding. Secondly, Chair, the selection of passages shows clearly a misreading or misunderstanding of the very passages relied on, and we'll go there to show that. Ultimately, there is nothing in the record that remotely approaches bias or a reasonable apprehension of bias.
And of course, Shahan, all of this was in response to the earlier arguments that had been made by Advocate Muzi Sikhakhane. And part of what we want to share with you now is basically confirmation of that there's a long game here. There's sort of a strategy and a tactic that goes beyond lodging this application for a recusal of the Deputy Chief Justice Raymond Zondo. Interestingly, Michael, of course, when Justice Zondo was asking, so what then happens when I recuse myself, yeah. Advocate Sikhakhane is saying, Chair, I simply don't have the answer to that.
And it's not my problem.
Yeah, in a way, it's not my problem. Don't make your problems mine, that you and the President would have to figure out how you proceed if you actually believe I'm right in my arguments about this reasonable apprehension of bias. But one thing that did happen, we had been speculating about this in the morning, that there's a longer game, there's a strategy to it all. Take us through that.
Always a marathon, never a sprint. And I'll say it, when it comes to Jacob Zuma, how many times have we today heard about the Stalingrad strategy, Muzi Sikhakhane taking offense to that, saying it was a very short battle, very strategically fought. And so he takes offense to the Stalingrad strategy. But where are we going tomorrow? The options are the Deputy Chief Justice rules, no, I'm going to recuse myself. What are the options that Jacob Zuma then has? Under instruction from Muzi Sikhakhane, sit there, invoke your right to silence, don't say anything, as we have seen with Dudu Myeni, or we're going to tie you up in review after review through the High Court, the Supreme Court, and ultimately the Constitutional Court. The long game, the game we know Jacob Zuma is most well known for.
In fact, we can take a listen to exactly that particular point from Advocate Muzi Sikhakhane.
If you blow us today, you don't agree with us, as I said, I have a mountain to climb. What happens? Do we get Mr. Zuma here as a guarantee? No. If we approach it that way, we will just, even if we lose, we will review you. We will go as far as wherever, and that's not helpful. If you force me to bring him here without the climate being created for him to believe that he's not being charged, well, I'll put him there, Chair, and he'll exercise his rights to say nothing. And I think those two things, as strategic as they may be for me as a lawyer to get my client out of this place, I think the country deserves a climate that can interrogate this subject matter without judging the people we already dislike.
All right, we're going to leave it right there. Thulasizwe Similane and Michael App.